Welcome to everyone. Happy holidays to all of you and your families. Thank you for joining us on this Tuesday afternoon, December 20th of 2022. We're going to get started today with my COVID update. Next slide, Kathy. So I thought it would be interesting not only to take a look at the last 90 days of new cases, but also if we compare them to the all-time case numbers. As you can see, last year around this time and through around February, end of February going into March, we had the largest spike in cases of the entire pandemic. We were getting up close to 80,000 cases a day. And I thought it would be good to offer a little perspective here. We've seen fairly consistent and flat numbers since really the early part of the summer this year. We've seen a little bit of a spike over the past 2 weeks, but nothing even close to what we saw in December, January, and February of last year. So I thought that would be interesting for you all to look at. I know that on last week's webinar, Gabe talked to you about New York City, the New York City Health Commissioner's recommendation regarding masking. Again, this wasn't a mandate, but we're seeing recommendations, at least from the CDC and the New York City Commissioner of Health. And I don't think they're limited to COVID. The basis for these recommendations are the explosion of influenza, COVID, and the other viruses that were respiratory viruses we've been seeing. So, all right, next slide. As we see again, anything north of New York City looks pretty good. New York City still is in that orange range, but nothing red, nothing dark orange. So we're doing fairly well in new case numbers. You can see on the chart on the right that hospitalizations have increased somewhat in the areas listed on the chart, but that is usually a lagging statistic. So we saw a sharp increase in cases over the past couple of weeks. And so that probably just means those cases or the hospitalizations are catching up with the increase in cases. So good news on the COVID front, we're nowhere near where we were last year. We've pretty much leveled off, and let's hope that we stay there. Okay, so we have a packed program for you today. Before we start with the formal presentations, I do want to advertise a little bit. In 2 weeks, we're going to do a year-end review. So on January 3rd, we're going to do a year-end review of the statutes, various issues that have come up this year that we presented on that have been very important to you. So look for that in the next 2 weeks. All right, first up, we have Tom Eron, who is the chairperson of our Labor and Employment Department here at Bond. Tom is here to talk to us about some recent NLRB decisions because there has been a flurry of activity from the NLRB and some decisions coming out that may really significantly impact you and your employees. So Tom, welcome on.
Thanks, Adam. Good afternoon, everyone. I've reported before on some NLRB matters, and I thought I would give you an update given this, as Adam says, a flurry of activity. Kathy, if you could flip to the next slide, that would be great. So just to reset, right, this is activity by the National Labor Relations Board, the 5-member board that sets federal labor policy. And we see this activity because one member, Republican John Ring, his term expired last Friday. And so there was a push to get out major cases which were being decided by the full board. Rather than the typical 3-member panel, these are decisions by all 5 members. And very typically with the board now and historically, the 3 Democratic members are in the majority and the 2 Republican members were in the minority in these cases. I'm going to talk about a couple of them and then turn it over to my colleague, Peter Wiltenberg, to address another. So Kathy, if you go to the next slide, the first case involves the issue of employee access to employer property for the employees to engage in Section 7 activities, right? Activities to form and join a union or to otherwise engage in concerted protected activity. And we've seen these cases in many, many scenarios over decades. And this particular scenario comes up where the employees involved don't work for the company that is responsible for the property. So they're employees of company A, and they regularly work on the property of company B. And you can think of a host of examples, right? The tenants in a larger office building or office park, a restaurant in a hotel or on a college campus, where the employees are the employees of the restaurant, but the actual physical location is on the property of the hotel, and the hotel is the owner, or the college is the employer. You also see it in manufacturing settings, right, or in a construction setting. So manufacturing would be where the manufacturer has contracted out maintenance services, for example, or IT services. And what we're talking about is employees who are off duty, who want to access that property to engage in Section 7 activities. The prior rule, which actually was established just 3 years ago in 2019, was that we treat those off-duty employees of company A like non-employees. So they have very limited rights of access, and the employer's ability to control access and use of its property are predominant. And only in the rare case where they would have no other feasible alternative to communicate with their coworkers or their audience, would there be an accommodation of the property rights which allow them to access the property. This board has reversed that rule and now set a new standard. Essentially, you can think of it as a presumption that these off-duty employees who regularly work on this property have a right of access and are only excludable if the employer has the burden of showing, the property owner employer has the burden of showing that their presence would significantly interfere with the operation of its property or disrupt its operations. And just so you understand the significance of this new rule, let's look at the facts of this case, right? This is a situation where the employees involved are musicians of a symphony, and they regularly practice and perform at a venue which was operated by the Performing Arts Center. On this particular occasion, the ballet was conducting a performance at that Performance Arts Center. And the ballet, which was a separate entity from the symphony, had chosen to use recorded music rather than hiring the symphony and those employees to perform. So the employees who were off duty, obviously not working because it's recorded music, came onto the property and were hand billing the patrons of the ballet to bring to their attention the fact that they were not being employed in this for this performance, and to encourage the patrons of the ballet not to patronize this performance because it had recorded music. And the employer, the venue, the Performing Arts Center, refused to allow them to stay on the property. And the board has now found that that was unlawful, that these off-duty employees of the symphony, who had no other reason to be on the property except to petition the audience, were to be allowed to do that. So you can see that while it's a unique set of facts, it has a very broad application to this question of when would these individuals be allowed on the property. And for the rest of us, it's a warning to act cautiously when intervening with off-duty employees who otherwise would have a right of access to the employer's property. And it also is going to impact for those employers who have other employers on their property, going to impact your no solicitation policies. Okay, Kathy, next case, next slide. The second case that I wanted to talk about was a case involving a company called Thrive, where the board really expanded the scope of the remedies that it would bring within the concept of make-whole relief. If you think about the typical case where an individual, for example, is discharged and the board finds that to be an unlawful discriminatory act, the board has the authority to award reinstatement and back pay. That's black letter law. But the law is broader than that. And the question of, well, what is the full scope of remedies that the board will issue in these circumstances has been debated significantly of late. We know with certainty that punitive damages and compensatory damages are not allowed, but the General Counsel has pushed for expanding the definition of make-whole remedies and including what's been described as consequential damages. The board did not go that far in this Thrive case, but it did clearly articulate that all direct and reasonably foreseeable pecuniary harms suffered by the employee would be subject to or included in the make-whole relief. So, what are we talking about here? Suppose that in this particular case, it was salespersons who were terminated and the board found it to be unlawful. So a salesperson who has a company vehicle as part of their compensation, you could reasonably anticipate that that individual, upon being terminated, would have to go out and either purchase or lease a new vehicle. And once it's concluded that that individual was terminated unlawfully, that the employer would be obligated to make up the cost of that vehicle lease. Another aspect of this for salespersons, which I can see is particularly difficult, is the concept that when they're reinstated, the employer has to provide them with a comparable book of business to restore the book of business. Other examples are an individual who's terminated would not receive 401k contributions. So those have to be added back in. But what about the earnings off those 401k, right? That would be something that would be a reasonably foreseeable pecuniary harm that has to be factored into the process of determining the final relief. The bottom line on this, and it ties back to the General Counsel's position in settlement cases, right? The General Counsel has told us and has effectuated this notion that they will only settle a case if there is full relief for the employees involved, is that it's going to make it much more difficult, time-consuming, and expensive to resolve these cases, and so increase the risks associated with conduct that is, potentially subject to challenge under the National Labor Relations Act. Make our job of assessing the pros and cons of taking a particular action, changing the balance in that regard. There was one other development that I wanted to make sure that our college and university clients were aware of, and Kathy, if you could go to the next slide. About a year ago, we learned that the current General Counsel was interested in reopening the notion of when are student athletes treated as employees and eligible for unionization and potential protection under Section 7 of the National Labor Relations Act. And so there have been some cases percolating on that topic. And this past week, the General Counsel authorized the issuance of a complaint against the University of Southern California. And the principal claim is that the men's football players and the men's and women's basketball players are employees under the Act, and that the university has acted unlawfully by classifying them as student athletes rather than employees, and has interfered with their rights, as discouraged them from exercising their rights under the law because of the classification. That's significant enough. But the other piece of this case, and where it really is going to take us, is that the NLRB is pursuing this claim against the university and the conference, the Pac-12, and the NCAA on a joint employer theory. It clearly appears to me that the Labor Board in this regard is trying to change the scope of or the treatment of student athletes across the country with this one case, because they could, if they prevail, and that's a big if, have a conclusion that the NCAA can no longer treat athletes other than as employees. And the permutations for that are extremely significant, not only for USC, but across the nation. So we're going to watch this case very carefully as it goes through the administrative process. And with that, Adam, I'll turn it back over to you.
Tom, thank you. Very interesting developments. And we're going to keep going with the NLRB developments. And here to talk about another significant case decision that came out from the board is Peter Wiltenberg. Peter is an attorney in our labor department in our Buffalo office. Peter handles issues regarding labor and negotiations frequently. So Peter, welcome. Take it away.
Thanks, Adam. So yeah, as Tom mentioned, we've seen a number of really significant decisions coming from the NLRB, and there was yet another one that came out last week on December 14th. So I will talk about that one. Next slide, please, Kathy. So this was a decision called American Steel Construction, and this really again modified a standard that's kind of been in flux a number of times over the last 10 years or so, having to do with bargaining unit determination cases. So this is a decision, as I'll get into in the next couple slides, that's really the impact of it is gonna be to make it easier for unions to organize sort of subgroups of job classifications within a workplace. And these are sometimes called or referred to as micro units. So next slide, please. When does this American Steel test or set of standards come into play? What are we really talking about here? So the situation is there's a labor union that is seeking to represent some, but not all, of the job classifications within a particular workplace. And to kind of illustrate this, give you the facts from American Steel. The proposed unit was basically the iron workers, the journeymen and the apprentice field iron workers at American Steel's workplace. They were trying to, be recognized as a union, as a unit, and the employer said, "Wait, hold on, that's too small of a group of employees. There should be others that ought to be included in that unit." And specifically, the employer said that it should also contain painters, drivers, and inside fabricators. So that's what the dispute was, and that's how it came before the NLRB. And what's at stake really with these kinds of cases is how difficult or how easy it is for these micro units to be recognized. And probably what's going on is there could be a couple of things from the employer's point of view. It might be that the employer suspects that the other group of employees who were excluded from the proposed unit would be perhaps less interested in joining the union, and perhaps, if all those are put together, then this group of employees, wouldn't be able to be recognized as a unit in the first place. Or even if not, from the employer's point of view, it can be much more difficult, cumbersome to have to bargain with all these different sort of smaller groups or smaller units composed of different kinds of employees, as opposed to a smaller number of units that include more employees. It could really make the bargaining process much more streamlined for the employer, of course, if there are fewer units. So when a dispute comes like this, how does the NLRB resolve this? What's the right balance between recognizing the right to organize versus the employer's interests and keeping this sort of to a reasonable number of employees or job classifications in each unit? Next slide, please. So in 2011, the NLRB issued a decision called specialty healthcare, and that set forth a test or a standard that made it pretty easy for these smaller micro units to be recognized. So under that test, an employer who wanted to challenge the composition of such a unit would have the burden to come forward and demonstrate that there was what's called an overwhelming community of interest between the proposed unit and the employees who were excluded from it. And this was a difficult standard to meet. It was well recognized or considered to be a boon for union organizing. The burden was high, the test was difficult. For it to be an overwhelming community interest is just hard to meet. So the result of this was that there were a lot of unusual kind of what we call micro units formed. An example was a unit of cosmetic and fragrance counter employees at a Macy's department store. If that unit had been proposed perhaps under a different standard, maybe the employer would have been able to force them to include, perhaps many more of the employees who work at the department store within that particular unit. Next slide, please. So then in 2017, the board issued another decision called PCC Structurals, and this overruled specialty healthcare. So beginning at that time, the board implemented this much more stringent standard that was a lot more favorable to employers. And so instead of the burden on the employer having to show the overwhelming community of interest, they would just, the test instead was a balancing test. And it balanced the interests of those within the proposed unit and the shared and distinct interests of those excluded from the unit. So this test was a lot easier for employers to satisfy. It took the burden away from them, as I said, and it no longer started with a sort of a presumption almost of deference that the composition of the proposed unit is acceptable, unless the employer can meet this relatively difficult standard. And under this standard, the employers had a far greater ability to challenge a proposed unit that they deemed to be, inappropriately small or as excluding some employees who they thought should have been included. Next slide, please. So now, as of last week with the American Steel test, we're completely back to the specialty healthcare standard and the specialty healthcare test and its overwhelming community of interest standard. So the board just fully, without modification, went back to that previous standard. So it talked a little bit more about what it thinks overwhelming community of interest actually means. And so one of the things that it says is, for an employer to actually meet that standard, it would have to show that there were only minimal differences from the perspective of collective bargaining between the employees in the proposed unit and those who had been excluded, and that there was no rational basis for the exclusion. And as many of us are familiar, anytime we see the phrase "no rational basis," we know that's a pretty hard standard to meet. So now, if a proposed unit is a clearly identifiable group of employees with a shared community of interest, the board will basically presume it to be appropriate. Next slide, please. So the takeaways from this decision are unions and employees are again empowered to organize along narrower lines of job classification. Unions are again likely to focus on micro units as a path to organizing. Employers are likely to have to prepare to face the prospect of multiple distinct bargaining units among their employees. As we all know, this is taking place in the backdrop of an uptick in union organizing activity over the last couple of years as it is. So this could very well help to propel that even further. Something we'll definitely keep an eye on. That's all I got.
Peter, thank you so much. And everyone look for a blog post from Peter on this case and its implications, which I believe is already up on the Bond, Labor, and Employment blog. Okay, next up, I am happy to welcome Lisa Feldman back. Now, Lisa has been on many times to talk to us about the various pay transparency laws that we've seen popping up in New York State. We saw one in New York City. We saw some counties that have adopted pay transparency laws, but now the big one, the state law, is imminent, I think I can say. And Lisa's here to talk to us about where we are on it and what it means for you as employers.
Thank you, Adam. Next slide, Cassie, please. So where are we, as Adam said? The bill was delivered to the governor on December 12th last week. The governor then has 10 days, not including Sundays, to sign, veto, or take no action. As of right before this meeting, it has not yet been signed. If the governor takes no action within those 10 days, the bill automatically becomes law. However, a vetoed bill is not the end. It would go back to the House it originated from, and with a vote of 2/3 of each House, meaning the Senate and the Assembly, they can override the governor's veto. If it becomes law, it would go into effect 270 days after becoming law. And interestingly, it would amend the New York State labor law, which is slightly different than what we've seen on these local laws, which have been amending the human rights laws. Next slide, please. Thank you. So who is a covered employer? It's pretty broadly defined here. It's any person, corporation, LLC, association, labor organization, or entity employing 4 or more employees in any occupation, etc., or any agent thereof, and any person, corporation, LLC, association, or entity acting as an employment agent or recruiter or otherwise connecting applicants with employers. And temporary help firms are exempt from the law, which is something that we've seen in other jurisdictions as well. But I'll note here that in New York City, even though we also have a temporary help firm exception there, the guidance has told us that employers who work with temporary help firms are still covered. So we may see similar language if rules or guidance get promulgated on the state law as well. Next slide, please. So what postings are covered? Very similar to where we started off in New York City. Advertisement is not defined in the law, but we do know that it covers any job, promotion, or transfer opportunity which can or will be performed, at least in part, within the state of New York. Next slide, please. So what must be disclosed? First, compensation or a range of compensation, which is defined as a minimum and maximum annual salary or hourly range of compensation that the employer in good faith believes to be accurate at the time of the posting of an advertisement for such opportunity. Again, good faith is not defined here, but I can tell you that in the New York City guidance, it's defined as an honest belief at the time of the posting. So it may be defined similarly. The state law also requires a job description to be disclosed if a job description for such opportunity exists. And it also notes that advertisements for jobs, promotions, or transfer opportunities which are paid solely on commission must make a general written disclosure that the position is commission-based. Next slide, please. What else does the law require? There is a record-keeping requirement. Employers must keep and maintain records in connection to this law, including but not limited to the history of compensation ranges for each job, promotion, or transfer opportunity, and job descriptions for these positions if such job descriptions exist. Next slide, please. What does the law prohibit? There is a retaliation prohibition written into the law. Employers may not refuse to interview, hire, promote, employ, or otherwise retaliate against an applicant or current employee for exercising any rights under this new law. Next slide, please. And there are enforcement and penalties. Any person claiming to be aggrieved under the new law may file a complaint with the Commissioner of the New York State Department of Labor, and civil penalties may be imposed of up to $3,000 for any employer who violates this law or any related regulations which will be promulgated, which the law permits to be promulgated. Next slide, please. And one last note, there is a preemption clause that the law shall not be construed or interpreted to supersede or preempt any local law, rules, or regulations. This will be a little bit interesting because one of the local laws in Westchester County actually has language that it will be preempted with same or similar law passing at the state level. So we'll have to see what happens with that. And we will be monitoring very closely to find out if and when the law passes, and we'll let you know. If you have any questions, my contact info will go up at the end of the program. Thank you and happy holidays.
Lisa, thank you so much. So I have a couple of comments here. One, that is a lot of information. This is one of those statutes that has some very specific requirements. So in addition to these slides, which will be available to everyone later this week, as soon as this bill becomes a law, we will be posting a blog that goes through the different obligations that employers have. So you will all have that as a resource. To the extent you have more specific questions, please feel free to reach out to Lisa. Again, this is one of the statutes that I know our clients are going to be looking at saying, geez, what are my obligations? What do I have to do? So we will make sure to provide you with many resources to help you with any questions you might have. Thank you, Lisa. We appreciate your time.
Thank you.
Okay. Last, but certainly not least, is Subha Viswanathan. Subha has been on before. What Subha and I talked about is a series on wage and hour basics. And for those of you who may not know, New York State and the federal government have wage and hour laws that provide rules regarding overtime, minimum wage, employee classification, all these little things that can trip employers up and are very important to make sure that you get right. Subha is a member here in our Syracuse Labor and Employment Department. Subha has been an expert in these wage and hour issues for decades. I think that's right, Subha. And he is going to do a series for us on various wage and hour topics. Today, he's going to start with New York frequency of pay requirements. But before we get to that, Subha, we got a number of questions, and I wanted to pose this question to you before you get started. We've all heard about the salary threshold for exempt employees in New York and whether it's going to go up at the end of the year. What is the status of that?
So thanks, Adam. So as of right now, we haven't heard anything definitive from the Department of Labor about those proposed regulations being adopted. We know that the comment period for the proposed increase in the exempt salary thresholds and the minimum wage expired on December 11th. So it's been 9 days since then. Everybody should operate under the assumption that those are going to go into effect. I don't think there's any doubt that they will go into effect. We just haven't heard definitively from the Department of Labor that they've been adopted.
And if I'm not mistaken, traditionally, the salary threshold has been 14 times the minimum wage, or not 14, but a certain
75 times
75, sorry about that.
Minimum wage is, yeah.
And we know the minimum wage is going up, so that's more evidence that the threshold will be going up.
Correct. And although the Department of Labor has kind of deviated a little bit from that 75 times the minimum wage, 75 times the new minimum wage would actually be $1,065 per week. They increased it, at least the proposed regulations increased it to $1,064.25. A little bit of a difference, but that would be the new exempt salary threshold for the executive and administrative exemptions.
Thanks, Subha.
All right, so I'm going to talk about the New York frequency of pay requirements. You can move on to the next slide, Kathy. This is not a new requirement. In fact, this requirement has been around for probably at least 100 years. It's codified in labor law section 191. Essentially, it says that manual workers have to be paid at least weekly within 7 calendar days after the end of the work week. There's a couple of exceptions. Not-for-profit organizations can pay manual workers semi-monthly without getting any sort of permit from the Commissioner of Labor. Large employers can obtain a permit from the Commissioner of Labor to pay manual workers less frequently than weekly. For the vast majority of employers, that's not a practical solution because you have to have at least 1,000 employees in New York State for the 3 years preceding the application, or have 1,000 employees in the 1 year preceding the application and at least 3,000 employees outside of New York State for the 3 years preceding the application. So it's only extremely large employers that are even eligible to apply for the permit. Clerical and other workers have to be paid at least semi-monthly, and commissioned salespersons have to be paid in accordance with the agreement and not less frequently than monthly. So as I said, this has been around for 100 years, but there's a reason why I'm talking to you about this. These requirements have recently gotten renewed attention for a reason that I'm going to talk about in a second. You can move on to the next slide. Thanks, Kathy. So I'm going to focus on the manual worker weekly pay requirement because it's generally not a compliance problem for employers to pay clerical and other workers on a semi-monthly basis. Manual worker in the law is defined as a mechanic, working man, or laborer. The New York State Department of Labor takes a very broad interpretation of what that means and has basically said that employees who spend more than 25% of their working time performing physical labor are considered to be manual workers. Next slide, please, Kathy. So this goes well beyond manufacturing, well beyond factory work, and includes a lot of classifications that you wouldn't ordinarily think of as being manual labor. Truck drivers, warehouse workers, construction workers, wait staff and cooks at restaurants, chauffeurs. There's a specific DOL opinion letter that says chauffeurs because they assist in putting bags in the trunk. Driving is considered to be a manual task. They're considered to be manual workers. Cashiers considered to be manual workers. Hairdressers, supermarket and department store employees, and janitors. All of these are considered to be manual workers. Next slide, please, Kathy. So until recently, the consequences of paying manual workers biweekly or semi-monthly were not very severe. Courts generally held prior to September 10th, 2019, that there was no private cause of action, which means that employees couldn't bring claims directly in court for a violation of the frequency of pay law. Their remedy was limited to filing an administrative complaint with the New York State Department of Labor. Courts also generally held, and the Department of Labor concurred, that these sorts of claims by manual workers who are paid less frequently than weekly weren't considered to be a claim for unpaid wages or an underpayment of wages. So under the law, there was no back wages or interest due. There was no liquidated damages available, which under the statute for a wage claim, for an underpayment or an unpaid wage claim, liquidated damages are available in the amount of 100% of the unpaid wages. So that was not available for these types of claims prior to September 10th, 2019. And no attorney's fees were available for these sorts of claims. The Department of Labor considered, and the courts considered these to be non-wage violations. So the remedies were limited to a civil penalty of up to $1,000 for the first violation, $2,000 for the second violation, and up to $3,000 for the third or subsequent violation. So importantly, those amounts were not paid to the employees who were paid late. Those civil penalties were payable to the Commissioner of Labor. So there was not a lot of incentive on the part of employees or on the part of plaintiffs' attorneys to bring these sorts of claims. Next slide, please, Kathy. This case, Vega versus CM and Associate Construction Management, kind of changed the whole ballgame in terms of these manual worker frequency pay claims. This was a First Department Appellate Division decision that was issued on September 19th, 2019. So this was a mid-level appellate court within New York State, really the first mid-level appellate court to address the issue. This court said that a late payment of wages is the same thing as an underpayment of wages. And basically the court's rationale for this was every time wages are paid late, the employee has not paid wages when they're actually due, which means that the wages were left unpaid. The court also held that a manual worker can assert a private cause of action in court for an employer's failure to pay weekly. A manual worker is entitled to 100% liquidated damages for all wages that are paid late. And the court also said that attorney's fees are recoverable. So if the employee succeeds on the claim, demonstrating that they're a manual worker, demonstrating that they weren't paid on a weekly basis, the employer is obligated to pay reasonable attorney's fees incurred by the plaintiff in bringing the claim. Next slide, please, Kathy. So just as a rough illustration of how insane the damages can get with an application of the Vega case, let's assume that we have a manual worker. The hourly wage is $15 per hour. So basically, let's assume that the employee worked no overtime for 6 years. For 6 years is the statute of limitations under New York law for wage claims. So let's assume the worker went 6 years, didn't work any overtime, worked exactly 40 hours per week for the entire 6-year period. That employee's biweekly wages were $1,200 per biweekly pay period. Under the application of Vega, a court would say that the compensation for the first week in each biweekly payroll period was late because it was paid more than 7 days after the end of the work week. So that's $600 in every biweekly pay period that was paid late. You take that $600, multiply it by 26 pay periods per year, multiply it by 6 years, that employee's liquidated damages are $93,600. And the employee would be entitled to get that, even though obviously the employee was paid in full for all work hours. Now, it's a rare circumstance where you have just one manual worker in a job classification. Most of the time, there's multiple people in that job classification, which is why these claims are often brought as a class action. Let's assume there's 100 manual workers during that entire 6-year period. The potential liability for the entire class would be $9,360,000. Next slide, please, Kathy. So as you can imagine, with these types of damages potentially available under the Vega rationale, there's been a huge increase in these Section 191 lawsuits. There's been over 100 lawsuits filed in federal or state court since the Vega decision. It's not known how many threatened lawsuits have been settled before being filed, because obviously there's no public filing in a federal or state court docket, but I'm sure that there have been other lawsuits threatened that were settled before being filed. Plaintiffs' attorneys have an incentive to file these claims as class actions because of the damages that are available, and the fact that if they're successful in bringing a claim, they get their attorney's fees paid by the employer. Next slide, please, Kathy. There is a glimmer of hope. there was a Queens County Supreme Court decision that was decided on April 20th, 2021. So just kind of to kind of give you a brief overview of the New York State court system for those who aren't familiar with it. There's 4 appellate divisions, and then there's lower courts within each of those appellate divisions. So Queens County is actually within the 2nd Department Appellate Division. And the lower courts within any particular appellate division aren't necessarily bound to follow a decision issued by another appellate division. So the Queens County Supreme Court was not obligated to follow the Vega decision because they are within the 2nd Department, and the Vega decision was issued in the 1st Department. So this Queens County decision went the completely opposite way and kind of, parroted the law as it existed prior to Vega, which is the violation of a frequency of pay law does not equal an underpayment or a failure to pay wages. So there's no private cause of action, there's no liquidated damages available, and there's no attorney's fees available. That case has been appealed to the 2nd Department Appellate Division. So if that case ends up coming down contrary to Vega, we'll have 2 appellate divisions that have issued contrary decisions, which means that the New York Court of Appeals, which is the highest court in New York State, may have to address the issue. At this point, it hasn't addressed the issue. Next slide, please, Kathy. So just sort of general advice and takeaways from this: the potential liability for paying manual workers less frequently than weekly is enormous under the Vega decision. So if you do pay on a bi-weekly or semi-monthly basis, you should evaluate if you have manual workers who should be paid weekly. If you have any doubt as to whether someone's job classification would be considered manual or not, you should assume that they would be considered a manual worker and change to weekly payroll. At this point, as I said, the Vega decision is the only mid-level appellate division decision addressing the issue. And obviously, some of you may fall within jurisdictions in the 3rd Department or 4th Department, which have not addressed the issue. So there's always the potential to make that argument that, hey, the Queens County decision was correct, the law as it existed prior to Vega was correct, but it's not worth the risk, because those courts may, even though they're not obligated to, they may find the Vega rationale persuasive and they may still follow Vega. Even if we ultimately get a Court of Appeals decision that says Vega was incorrect, plaintiffs are limited to going to the Department of Labor, and the only remedies available are the civil penalties payable to the Commissioner of Labor, it's still a good idea to comply with Section 191. If you have manual workers, pay them on a weekly basis. You don't want a Department of Labor audit. So even though that may be the limit of the employee's remedy, is to file an administrative complaint with the Department of Labor. Once that complaint is filed, the Department of Labor is not limited to just investigating the complaint that was filed. They can examine your payroll records, they can examine your time records, they can examine your job classifications to see if you're properly classifying people as exempt or non-exempt. So the possibilities are endless if you get into a Department of Labor audit. To avoid that liability and to avoid those civil penalties, just try to come into compliance.
Suba, thank you so much. We're a little over today, but I think it was great content. I know a number of you had questions for Suba. Please feel free to reach out to him directly. If you have any questions on any of the other topics, here's the contact information for the speakers today. Thank you for joining us today. We hope you have a happy holiday season, and we will see you next week.